morning. Please be seated. To begin, I'd like to welcome those of you from Madison Meadows School. We are just honored to have you here, being interested in what we do for a living. So thank you for coming and paying attention. All right, Council, good morning. We are here for oral argument in cause number CV240363, Milliman et al. Versus Berry. These proceedings are being video and audio recorded as well as live streamed, so please introduce yourself and your client at the beginning of your presentation. Each side will have 20 minutes in which to argue. If you would like to reserve any portion of that time for rebuttal, that is up to you. Also, we have read the briefs. We've discussed this case in conference this morning. We're familiar with the facts. Please bear that in mind during your presentation. At this point, Council, if you are ready.
Thank you, Your Honors. May it please the Court, Al Arpad for Appellant David Berry. Please let me know if you're having any difficulty hearing me through the mask. I'd like to reserve 4 minutes or so for rebuttal. And I won't spend time on the summary judgment issues as to the location of the easement, since we already know what your views are on that, unless you see some difference in the situation or have some questions for me. We'll just reserve that for further review. So then that gets us to the big issue in this case, which is different from the other case, and that is the finality of the original judgment. I want to start by assuring you that I am not doing this just to torment you and everybody else involved. It is important for my client to know the answers to some of these questions and to know which things are precluded by the prior proceedings. So, for example, the 2022 decision in this case seems to strongly imply that maybe the county owns this strip of property that we're talking about, the easement property. But then the decision last week, I've had 2 different lawyers tell me that that just clearly establishes that Mr. Berry is the owner of the property. I don't think it does, but it's something we're going to end up having to argue about. The county is saying that something different applies. And so I am hopeful that the decision in this case will further clarify things, because if it doesn't, I'm very much afraid that we're going to be back here again next year and possibly the year after that with decisions that don't actually decide anything. The basic problem, the practical problem with the judgment, the original judgment in this case, as the county essentially admits, is that ownership of the strip that is supposed to have an easement on it wasn't really litigated and wasn't established. Now, the county has come into the 3rd case in this series and said, well, really, the prior proceedings do establish who the owners are, but that's only before you in a very abbreviated form at the end of the county's answering brief, and I doubt you're going to head down that road. But please let me know if that is something you're interested in and want my thoughts on. So the basic problem is that an easement is essentially hypothetical if you don't have the owner of the underlying property in front of you. So that gets us all to all the technical reasons why the judgment in the case wasn't final. The first one is the lack of a default judgment, and I honestly don't see how we get around that. 2 of the named defendants in the case didn't appear and defend, and somehow judgment got entered against them without going through Rule 55 proceedings. So if that's a thing that can be done, I hope that you will clarify.
Isn't that an issue for them?
Not in terms of finality of the judgment.
How does that affect your client?
Because it makes the judgment non-final if it doesn't dispose of all claims against all parties.
But the judgment says it does dispose of all claims in all parties. So why isn't that enough? On its face, would you agree that just reading the judgment, it's final? It has 54C language. It says it is.
The 54C language doesn't actually say all pending or no more pending claims, but it does have it does say 54C, and it does say this is intended to be a final judgment. That's definitely true.
So someone else coming in and looking at, I mean, as to everyone else in the world, why would that not be a final judgment?
Well, you've got multiple other problems. You've got the fact that on its face it says there's an easement but doesn't establish who owns the underlying property. And that's exactly the problem that we have in the other case. Now, maybe you'll come to the conclusion that, okay, it is all right to have a declaratory judgment case like this without the servient owner. But if that's the conclusion you come to, I sincerely hope that you will tell us that we have not in fact decided who is the servient owner, and we don't think that's precluded by the prior cases. If we know who the servient owner is somehow, it would be extremely helpful if you would tell us that. If we don't know who it is, it would be extremely helpful if you would tell us that, because right now we're back in the trial court relitigating whether that's already been decided, and we'll be back up here on preclusion before we even have a chance to ever address the merits in that case if we don't get clarity coming out of this case.
But you would agree that if this is a final judgment, that the relief request was untimely?
Yes, I think we said that right in our motion right up front. We said we understand how the rules work. We can't file a Rule 59 motion at all if the judgment was final, and the only relief that we can get is under 60B6 for new things that came up since the judgment was entered that aren't covered by any of the other subsections in 60B. So I think we were pretty clear like that and about that, and I'm clear about it today. The other issue is prior adjudication. This strikes me as interesting, but the county claimed for the first time in their answering brief, I think, that the Court of Appeals in the 2022 case had said we have jurisdiction, and that's preclusive of anybody litigating whether they had jurisdiction again. I think we answered that in our reply brief, and we said that there's a recent Supreme Court case that says we don't accept that low presumption standard. It has to be actually decided in order for it to really be preclusive. If you have any questions about that, I'm happy to try to answer them. But interesting issue, but I think it's not preclusive, and I think the Arizona Supreme Court has been pretty clear that void means void. When you have a decision that doesn't meet the requirements of being a final decision, it's void as a judgment. I will note before I leave the topic that the flood control districts, and please excuse me if I say county for flood control. I've had that problem throughout the case. If you have a question about who I mean, please tell me. I'll try hard to say flood control when I mean the flood control district. The flood control district has said that Barry can't get relief now because the county's not a party, and yet how did they get relief without somebody who might have owned the property in the original case? I don't understand how both of those things can be true at the same time.
Is it a question of who can raise the claim?
Well, my client certainly has an interest. I mean, my client's one of the claimants who might have owned the property. At the time this litigation started, he was confident that he was the owner of the property through that default judgment. As we've had all these twists and turns and disclosures and things that have happened since then, I honestly don't think that's the case, and the position that we're taking in the third case is different because of new information. But my client certainly does need to know that. That is, we're actually now on decent terms with two of the other owners and talking to them, and it's extremely difficult to figure out how you settle this if you don't know who owns the property. It's important. And that brings me to my final point on the issue of finality. If it is final, we need to know who it's final against, if you can possibly tell us that. Because again, it's coming up in the subsequent litigation. One of the parties, Coupon, who would not have been bound because that party was not done as a default judgment, now has a successor who is an opposing party who is going to take positions, and I don't know if that person's bound by this or not. So anything you can do to give us clarity on that would be extremely helpful. As I said, if the judgment is final, then we don't need to make the Rule 59 arguments, and most of those Rule 59 arguments have to do with the location of the easement anyway, which I already said I'm not going to go into, so I won't. That leaves us to the more limited relief that can be granted and should have been granted under Rule 60, B6, if the judgment is final. The first of those is the effect of the road declaration, which we brought up in the motion. Even if the judgment is final, we need to know what effect that has. I don't think that first of all, the county, as we pointed out, wasn't before the court. And if that road declaration was effective, then the county's the owner. So maybe it's not effective against them at all. Or maybe the county has to be brought in so that it can be made effective against them. Or maybe the court can't affect the county's legislative act of accepting a road. We don't know the answer to any of those because the trial court just refused to address it and said, I'm not going to reverse a decision of the Court of Appeals. That is something subsequent to any decision of, or at least that emerged subsequent to any decision of the Court of Appeals and has to be dealt with in some way or another. If this case simply isn't the case to do it, please make that clear so that we can try to do it in the third case. The other one is the parcel changes, and this is just a situation that I have trouble understanding, but for some reason after the 2022 decision, the county, not the flood control district, the county decided to change the parcel numbers that were the basis of the decision that the county had gotten. So you had those strip parcels, 012 and 013, that constitute most of the easement. And the county decided to change its map so that those parcels no longer exist on the theory that really it belongs not to anybody who owns a strip, but to the adjacent owners the other way. When I go like this, do you know the maps that we've all looked at several times? This may seem like a trivial administrative issue, but in fact what we've got is a judgment that only describes the easement by parcel numbers that do not exist. And so that's just a practical problem for everybody. And even if I'm wrong about everything else I've told you so far, the judge should have said, okay, let's issue a judgment with a proper legal description based on meets and bounds. Or the eastern side of that strip is a section line. It's one of the easiest properties in Arizona to describe, in theory. At the very least, we were entitled to some kind of relief like that so that the judgment reflects reality and my client and all the adjacent landowners have something in the chain of title that says what their access is. That's all I have for you. I'll reserve the rest of my time for rebuttal if I need it.
Thank you, counsel. When you're ready.
Thank you, Your Honor, and good morning. My name is Sean Moore. I'm with the Maricopa County Attorney's Office. I represent the Flood Control District of Maricopa County in this matter. With me at council table is Wayne Peck. As a bit of a programming note, I'm here to talk about most of the issues in the case, the Rule 60 motion, finality of the judgment. And if you have sort of intense land use questions, those are for Wayne to handle. I would also like to start by congratulating Wayne on his retirement earlier this month. It's well earned, and I would like to thank him for promptly unretiring so he could be with here this morning, or with us here this morning. All right, so
he's doing it wrong.
Some may argue that, Your Honor, yes. So there are really two issues before the court today. One, whether the judgment in the district's favor was final, and two, whether the trial court abused its discretion in denying Mr. Berry's motion for Rule 60 relief. Given the panel's recent decision in the Milliman appeal, where it explicitly said that the judgment in this case was final, I'm not going to address any of the finality issues in this case, in this appeal. If you have any questions based on finality, I'm happy to answer them, but I'm just going to go straight to the Rule 60 motion. All right. So moving to the Rule 60 motion, the trial court was well within its discretion to deny Berry's motion because it had several fatal flaws. First, there was no compelling reason to grant Rule 60 relief. Mr. Berry essentially offered two categories of reasons why Rule 60 relief should be granted. Neither of them are particularly compelling. The first group of reasons is essentially an argument that the prior trial court and this court in Berry 1 simply got it wrong. They provide maps and other things saying, oh, well, these courts mislocated the road and all that stuff. And that's just simply not a compelling or even available reason to grant Rule 60 relief, because the trial court has no jurisdiction to overturn this court and its determinations. The second group of reasons why Mr. Berry asked for Rule 60 relief is all based on subsequent actions taken by non-parties to this litigation. I mean, Mr. Arpad thankfully corrected himself, midway through his speech there, but the flood control district is not Maricopa County. They are separate political subdivisions of the state. The flood control district and Maricopa County do not make decisions for one another, and the flood control district does not make decisions for the county assessor. So Mr. Berry has provided no authority or any other basis whatsoever to say that subsequent actions by non-parties is a valid reason to grant relief from a judgment. The second reason why the Rule 60 motion was properly denied is that it was untimely. As this court and Mr. Arpad discussed earlier, the Rule 60 motion was given in 3 years after the judgment and 2 years after this court had affirmed that judgment, and that's simply out of time for a Rule 60 motion. They try to get around this by trying to rely on Rule 60b-6, which has to be brought within a reasonable time. They can't bring it under 60b-6, as I'll talk about in just a moment. But even if they did bring it under Rule 60b-6, the trial court explicitly found that it was still not brought within a reasonable time to be brought under that rule. They provide absolutely no basis whatsoever for saying that determination was an abuse of discretion, and so it was untimely, regardless of what subsection they try and go under. And then finally, there's no appropriate basis for relief under Rule 60b, the third reason why the Rule 60 motion was properly denied. Mr. Berry primarily relies on Rule 60b-6, but he falls well short of meeting this rubric. To be entitled for relief under subsection b-6, it must go beyond the other enumerated bases for Rule 60 relief, and the movement must also show that there is some kind of unusual or particular injustice or prejudice that he suffered as a result of the judgment, and Mr. Berry doesn't come close to showing either.
What's your response to counsel's suggestion that there's a problem, that the county's changed parcel numbers, the legal descriptions are not clear as to where the easement is? How do you respond to that?
Right. So to the extent there's any confusion in the judgment, and the panel did this in the previous Milliman appeal, it corrected the judgment to say, all right, here's the parcels and exactly where the easement is. If the court wanted to do that in this case, I mean, the Berry 1 opinion, or decision, I should say, it was not published. The Berry 1 decision has the legal description right there. It describes exactly where the easement is. If the court wants to amend or correct the judgment to just include that legal description, that's fine, but that's not a sufficient basis to revisit the whole prior litigation and everything that was decided by the trial court and this court in Berry 1.
Do you agree with the description as set forth in that decision?
I do agree with the legal description as set forth in that decision, yes, Your Honor.
In Berry 1?
In Berry 1, yes. So the first decision on this appeal between the district and Mr. Berry. But that's the only relief that would really be appropriate from that. If there's any confusion, the solution is to clarify the confusion, not relitigate the whole case. All right.
But assuming people have access to that decision, there in theory should not be confusion?
There should not be confusion, but if the court deems it appropriate to correct the judgment, we have no complaint or argument against doing so.
Well, after we corrected the judgment in Milliman, did the Superior Court reissue a judgment, or?
If that happened, I did not receive any notice of that, Your Honor. I don't know one way or the other. So I can't answer that question for you right now, unfortunately. But yeah, we are. It's consolidated. Sorry, I'm having a conversation with Mr. Peck. All right. So back to the Rule 60, the reasons why it's not an appropriate basis for relief under Rule 60B. Far from going beyond the enumerated bases under Rule 60B, it doesn't meet any of the bases in Rule 60B. It doesn't even come up to that standard. They basically try to enumerate two grounds. One is new evidence, but their supposed new evidence was on the public record since 1998, and the only way it counts as new evidence is if it couldn't have been discovered through reasonable diligence. And being on the public record, they can't show that reasonable diligence. And then for fraud, they claim that the district committed some sort of fraud by not bringing up road file 5045. But road file 5045 is irrelevant for the reasons we very briefly discussed in our brief. One, and two, again, it's on the public record. There was nothing to hide. Nothing was hidden. They could have found it at any given time. They just didn't. And so they don't meet the standard under either of those. And then they don't even attempt to show why there's some sort of unusual circumstance or of injustice or prejudice that would warrant relief under B6. So really, those are the three reasons why the trial court was completely within its discretion to deny Rule 60 relief. And unless the court has any further questions for me, I will yield the remainder of my time. Thank you, Your Honor.
Just a couple of things to clarify, Your Honor. Let me start with the legal description in Berry 1. This is taken from the original Willis deed, and it describes essentially strips going all the way around a parcel. So it's substantially different from just the east side of the parcel, which is what we're talking about here. That description also says 40 feet wide instead of 30 feet wide. There are some other reasons why it would be a little more you can't just adopt that wholesale and use it as your description. Now, as I said, it's not terribly hard to get a description, but we probably need to know how many feet long it is, and we probably need to know that it has that dog leg that you can see at the end that actually goes over somebody else's property, which is due to there being a culvert at the bottom of the strip. So there are reasons why you actually need a legal description here, and why you probably can't do it just by looking at Berry 1. The second item is time.
Are you saying the county would disagree with what you're suggesting?
Well, he just said something different. Are you pointing to something different than that at the beginning?
This is a legal question.
Okay. I mean, if you look at it, you can see they're talking about 40 feet around the outside, and we're talking about 30 feet on the east side, and you got to figure out where McDowell Road fits into that and so forth, and the box culvert for that matter.
Mr. Arbit, isn't this something that you can just bring up with the county recorder? It seems to me like you can take our decisions and say, okay, here's what it is, please change it. And if he says no, or she, I don't know gender of the county recorder, then you can bring an action against the county recorder.
Well, that's what we've tried to do in the third case. Well, not the recorder, it's more the assessor. The assessor is the one with the maps.
Whoever controls the maps. It just seems odd that the Court of Appeals is sitting there writing out legal descriptions.
I agree you should not. I'm sorry, did I interrupt you?
It just seems like that's not really our function.
I agree you should not do that. I think you should tell the trial court to let us sort it out because there are a bunch of parties and they so far have not agreed on much of anything.
Well, I'm not sure why we need to tell anybody. We've issued decisions in the past that have answered questions, specific questions. And now it seems to me that you can take it to whoever is in charge of the maps and say, fix it.
At least as far as the underlying ownership, that's not possible. We might, if we could get all the neighbors to sign off on it, we might be able to get the easement described. We still wouldn't know who the underlying owner is. But so far, I haven't been able to get all the neighbors to agree on anything. One of them has a restraining order against my client.
The significance of who the underlying owner is?
To know whether it's enforceable. I mean, at some point, this road needs to be improved if it's going to be a road with a bunch of houses on it. And nobody wants to volunteer to do that when they don't know who owns the property and who's going to come in next week and say, no, you did it wrong, do it over, or something like that. And that's been the history of this case. We can't get anybody to agree. I mean, I'm trying very hard, and we're making progress with a couple of the other parties. But in the past, we have not been able to get anybody to agree on anything, which is, like many cases, why we're here. Second was timing of the Milliman judgment. Judge McMurdy, you had a question. If I understood correctly, the Milliman appeal decision just came out and no mandate has issued yet, so the trial court has not done anything. Does that answer the question you were asking?
Yes.
Okay.
Is there a petition for review pending in that case?
Petition for review would be due at the end of the month due to the motion for reconsideration just having been denied. And honestly, we probably will have to file one just to keep things open until we get some answers on things, because we just don't know which way this is going to go in terms particularly of the ownership of the underlying parcel. And that's why we had asked you to take judicial notice of some of those things from the third case, because you can see that court is also not inclined to answer who owns the property. The last thing is with regard to the grounds for Rule 60 relief. We didn't argue fraud under Rule 60. We didn't argue newly discovered evidence under Rule 60. We argued that this county action is a thing of independent legal significance that nobody knows how it affects the judgment. And so there has to be some kind of a proceeding to figure that out. And the proper place to do that is in the trial court if you tell it to do that. That's all I have if you have no more questions for me.
All right, thank you, counsel.
Thank you.
We appreciate your arguments here today. Go ahead and have a seat. We appreciate your kind attention and to this argument and appreciate you guys all giving it your all. I know it's a little bit confusing that you probably don't understand exactly what was going on. Maybe the lawyers will give you a brief description of it when we leave. But at this point, we are going to take this matter under advisement. We will take a brief recess to reset the courtroom. We are at recess.